welcome to another Ethic Talk. I'm Jake Weiner, a fellow in Ethics Domestic Surveillance Project, and with me today is Ari Waldman. Ari is a professor of law and computer science at Northeastern University, where he's the faculty director of the Center for Law, Information, and Creativity. Previously, he taught at New York Law School and Princeton University. In his second book, Industry Unbound, the inside story of privacy, data, and corporate power, he goes inside tech companies to show the failures of privacy law in the face of corporate mischief. In 2020, Ari was named one of the top 20 thinkers of the year by Prospect UK magazine. He is also a widely published scholar, with articles in leading law reviews and peer-reviewed journals. Ari is the founder of @legally_queer, an Instagram and social media account that educates and empowers those interested in the role of law and the courts in LGBTQ liberation. He holds a Ph.D. in sociology from Columbia, a J.D. from Harvard Law School, and an A.B. magna cum laude from Harvard College. You can find him on Twitter at Ari Ezra Waldman. Ari, thank you for joining us today.
Thank you so much for having me.
So I thought we would start by talking a little bit about your career path. And can you tell us how you got interested in privacy law and maybe how that interest has directed your career?
Sure. So it's been a while already. I was a practicing lawyer for about 5 years, along with a clerkship. And when I started practicing, which was in 2005, the kind of assignments that I got were these complex internet-related litigation. But the things that came across lawyers' desks in 2005 that were complex internet litigation were mostly IP related, intellectual property related, which wasn't my passion, but it was, when you work for a big firm in New York, you just get what you get. That said, in certain meetings at my second firm, Winston & Strawn, when I was an appellate and critical motions litigator, a lot more of our clients were talking about privacy issues, we're talking about FTC issues, and I asked the signing partner, do you have any privacy issues or privacy related things that I can work on? So that's what I did in practice, but I have to admit that isn't what translated into my work as an academic. I knew I wanted to be a teacher, and so I did a fellowship, a work to academia fellowship. And when I started that fellowship, it was September of 2010, which is 11 years ago already. And that month, I think it was 5 young queer kids committed suicide as a result of cyber and face-to-face bullying. So I became significantly interested, not just as a matter of academic curiosity, but also as a matter of personal importance and advocacy as a cisgender gay man, that something that we need to learn more, understand more, and do more research about online harassment. Through that, I met some of my mentors and friends like Danielle Citron and Frank Pasquale and other people. And as a result of doing some work about how people behave toward one another online, I became far more interested in the sociology of internet behavior, and then privacy in general while I was doing my PhD. And as they say, the rest is history. But as an academic, I have to admit, as I see many junior scholars come in today, many of them have already found their voices, have already developed clear research agendas and have specific goals and clear understanding of who they are and what they want to be as an academic. And at the beginning, I did not. I only found my voice after a couple of years of figuring out where is my contribution and what can I say. And it was at the intersection of sociology and law, and how technology can sometimes reify power structures and keep marginalized populations down.
Yeah, so I think briefly, I'm interested how exactly you decided on sociology. Like, you're in a law practice, you have a fellowship that's transitioning to academia, like what about sociology attracted you?
Well, I didn't like being a lawyer. It wasn't the best experience in my life. I think that had a lot to do with, admittedly, my immaturity, but also the structural inequities that are imposed upon people in a big law firm life. So even setting aside the rank sexual harassment that I experienced or sexual orientation harassment that I experienced as a gay man in a law firm, I would say what got me interested in sociology or taking a PhD in sociology was the fact that work on cyber harassment is really about how groups of people behave online. What are the patterns of interaction? What are the motivations for groups of people and how they behave toward each other, and how those behaviors constitute social and legal institutions in our society, which is essentially just a modern version of sociology. Max Weber and Emil Durkheim, they talked about how groups of people behave inside institutions, whether those are nation states, cities, or corporate institutions. And this is how we behave toward one another, or how our interactions construct or socially construct social media is essentially just a modern form of sociology. So during my doctoral studies, I learned about the field of science and technology studies, which is about how knowledge, inventions, new information, just knowledge, new technologies are essentially the creation of social structures. The people that are involved in building or creating new inventions, but also the people not in the room, right? And how both people's presence and people's non-presence in the creation of knowledge affects what that knowledge turns out to be, and how that knowledge is used and leveraged in society. And that has incredible implications for law, because if we are thinking about how we, say, socially construct social media, or how online dating apps are used in society, and how we should think about regulation, sometimes we have to think about, well, how do these technologies come to be? Who was left out of the process of building these technologies? And what does them being left out mean for how it affects the broader population? And when that involves things like discrimination, reifying biases, and so forth, that's sometimes when law has to step in.
Yeah, I think that's incredibly important, and also I think work that we need in the legal academy, since so much of legal doctrine is kind of about ignoring power imbalances and papering them over with law. So I think that analysis is fantastic. To pivot quickly, I'd like to talk a little bit about your latest book. Can you maybe give a brief overview and then talk about how you set up the interviews that you did? Because I understand that that's kind of the basis.
Sure. So the elevator pitch for Industry Unbound is that this is the story of what companies actually do when it comes to complying with privacy law. Behind all the marketing, behind all the puffery, behind what they say they do, I went inside technology companies and tried to avoid formal presentations by company management, and instead spoke to the real people who are doing the work on the ground. So whereas some other scholars spoke to executives and chief privacy officers, I spoke to the privacy managers, the analysts, the software engineers who are building tools, the sales representatives who wanted to increase engagement, the designers, the software engineers, the programmers, et cetera, and put these all together into a way to understand how our companies, not just existing in informational capitalism, but what do they do as a matter of daily practice to make it so that our privacy laws don't really do much, right? So everyone talks about how privacy law is getting stronger. We have new statutes. We have the GDPR, which some people call groundbreaking, and how they call the CCPA, the California Consumer Privacy Act, even as amended, as the strictest privacy law in the United States. So we see privacy law proliferating, and we see scholars and commentators talking about how important and how much impact these laws are going to have on our privacy. And yet we still see companies building products that are data extractive. So how do we come to terms with that? Do we just say that, oh, well, they have a financial interest in a data extraction? That doesn't really explain why our laws are so ineffective at reining in the excesses of informational capitalism. It turns out that it's not just an accident, and it's not just executives who don't care about our privacy. It's actually a purposely designed system in which companies use discourses of innovation, discourses of privacy as control. They use compliance structures like privacy offices and record keeping and audits, as well as the organization of a company to silence privacy voices at every step of the way. And they do this so well that even people who think of themselves and brag about themselves as privacy advocates inside companies don't realize how their work is actually serving surveillance goals in the end. And that's what Marxist scholars would call hegemony, or what Foucault would call a technique of power. The work that these companies do are so all-encompassing that even people who have non-data extractive interests or come to their work without just thinking, oh, I don't care about privacy, I want to screw over our customers, even their work is channeled toward informational capitalistic ends because of the way company structures limit and constrain their work. So this book really tells the story about how informational capitalism works on the ground. And I see it in the tradition of building off Julie Cohen's masterful book, Between Truth and Power, and showing how not just how economic actors use law to amplify their power, but how they act on an everyday basis to weaken the ground under which we write privacy laws and undermine those laws when they actually come to be passed.
That's fascinating. So I think that we'll pivot to the legal side in a little bit, but can you maybe provide an example of what that looks like on the ground for like a person who's working at, say, Facebook?
So sure. So a company like Facebook can say they care about our privacy. We've all heard that. Every single company says, your privacy is important to us, or we care about your privacy. Sometimes they even say, we care a lot about your privacy. But it matters what these people mean by privacy. So when Facebook, for example, they talk a lot about privacy. Mark Zuckerberg testified before the Senate about privacy. His chief legal counsel, his chief privacy officer issue these reports about how much work they're doing for privacy or to enhance or protect people's privacy. But when they talk about privacy, they talk about it in terms of control. They talk about it in terms of giving us the opportunity to consent or not consent to certain uses of our data. But as so many scholars have talked about, and I've talked about, many other people far smarter than I have written, control is illusory, right? An interview you should do is with Woody Hartzog, and where he talks about the illusory nature of consent and control in his book, Privacy's Blueprint, which I have sitting next to me. But what I add in this book is not just how control is illusory, but how systemically companies make their employees feel that privacy is about control. And it's sometimes very simple things. Someone can come in and work for Facebook thinking that they really care and want to change that company's culture about privacy. But if the only assignments that they receive as a privacy analyst are about how are we improving the ways people can control what happens to their data, if the only assignments that they receive are defined or embed definitions of privacy that are about consent or control, not only are you going to come to see privacy in terms of consent and control, but your work can only be directed toward those ends, right? If a company says to a design team, or if a product manager says to their design team, that team over there is going to be in charge of privacy. You're going to do this. You're going to do assignment A. You're going to do assignment B. You're going to do assignment C. Some of the teams in working on a particular product, they may have thoughts on privacy, but that's someone else's work. right? So they can divide out who does what and keep privacy siloed. And even for the privacy team, companies will say, well, these are the things that we can do about privacy, or this is what can be codable, an engineer might say. This other stuff about our privacy expectations and things that are a little fuzzier or a little more value-oriented, when engineers control what privacy means, privacy gets reduced to buttons and codable pieces of privacy protection, or what AI can understand as privacy. So there are tons of ways that are embedded inside how people do their work and inside how corporations are structured, that merely thinking about informational capitalism is incompatible with privacy doesn't really get. And those kinds of stories are what's described in this book.
Yeah, that's fascinating. So where do you see the law falling short right now, or where's the process to make law falling short? So I understand that that's part of your argument.
Everything is falling short right now with respect to privacy. In short, the problem with the kinds of privacy laws or privacy proposals that legislatures in the United States are writing now is that we are very much path dependent. We're path dependent in that we see privacy law as a certain narrow band of options. And I saw this a lot in my interviews. Sometimes after being told that at a company, oh, we just enhanced our privacy protections by giving you, the customer, more control over where your data, over when or what types of data we collect by providing these new buttons or providing more consents, I asked them, well, why did you choose this approach? Or what about a different approach that would provide more substantive privacy protections, like simply not collecting certain information? And then often the responses are, but that's not what we do. That's not privacy law, right? And what's remarkable about that is that people of all jobs, software engineers, privacy analysts, lawyers, salespersons, they come to their work with these perceptions of what privacy, not just what privacy means, but what privacy law should require. And when you look at the laws or proposals that we have out now, we also have this same perception that privacy law is a series of individual rights and a series of compliance obligations. So you have rights to access, you have right to delete, you have rights to collect, you have rights to opt out, or some combination or additions of those. And then companies are required to keep records, audits, report every 2 years, hire a privacy officer. This is in some ways similar to the GDPR, but some ways different. But this idea that privacy law is what Margot Kaminsky described as this binary form of governance, individual rights and compliance. This idea is not just dependent upon outdated visions of privacy, i.e. that privacy is some individual right, but also that we are capable of actually taking agency, overcoming the cognitive biases that are built into us and that are nudged by dark patterns and so forth and other design tricks to be able to exercise our rights. And it also ignores the fact that managerial forms of governance like internal audits and privacy offices are entirely controlled by the company and easily subject to capture. So in a world where we are influenced by neoliberal discourses, where internal managerialized structures are what pass for neoliberal regulation these days, and where the onus is on the individual to protect their own privacy, pretty much all of these statutes, or roughly all of these statutes or proposals that are out now, take this similar approach. And as a result, they are not filling the gaps, they are not doing anything more, or not achieving the kinds of substantive privacy protections that we might need in order to make a difference. So the problem is not just that we are influenced by neoliberal discourses or that we have no capacity for public governance now. It's that people think that the Overton window of viable privacy governance structures are the precise kinds of privacy governance that companies want, because they're so easy to co-opt and very easy to avoid changing anything about their business model.
Yeah, thank you. So I think that if we are pushing to envision privacy as a collective good and not just an individual good, what would a regulatory structure look like that could move us in that direction?
Well, there's no one magic bullet for this. It's very easy to start by saying we need massive investments in public governance, massively more empowered FTC, or whether you want a new or a new agency, right? So massively empowered public governance. But even beyond that, right, that's not gonna massively empowered public governance in a system that is based on internal audits and record keeping is not gonna really change anything. So the only way to move forward, if we want to stem the tide of a life that's totally commodified by private corporations, is to regulate the business model. Right? We exist in a world where we just assume that an advertising-based business model is how the internet works. And an advertising-based business model requires targeting, and it requires enormous amounts of data, which requires data extraction. And if we start thinking about privacy law instead as about regulating the basic framework in which these enormous companies collect and profit off our data, then we'll start making changes. So for example, how do we regulate the business model? Well, we need a significant conversation about making these companies smaller. So making companies smaller is not the full answer, because instead of just big companies collecting our data, you still have just small companies extracting our data, but it's part of the process. The bigger the company is, the harder things like content moderation are. The bigger company is, the more less competition they have for our business, and the more they can extract our data knowing that there's not going to be any market effects. So we definitely need to consider making these companies smaller. We definitely need to consider prohibiting certain types of micro-targeting, whether it's political micro-targeting, whether it's using certain types of data to target us for advertisements. We need to consider preventing companies from enriching themselves on a simply data extractive model. There are other things, right? Part of protecting privacy is going to be through unionizing tech workers who are working on privacy and artificial intelligence. Companies are never going to change if they can control all of the discourse. That includes protecting employees. It includes giving academics access to company data, which they control, and therefore can control the narrative about what happens and what our data means. It also means civil rights protections. I think a civil rights agenda is not the only thing that's going to solve this problem, but it's part of it. Nor are things like private rights of action going to solve this problem, because if you turned on a private right of action tomorrow, that private right of action is going to exist in a world of narrow standing, which we've seen Supreme Court cases just this term about. Apparently now Congress can no longer create rights. They have to, even if Congress creates a right statutorily, an individual still, according to Brett Kavanaugh, needs concrete and particularized harm in order to get into federal court. A dream of the conservative judicial movement of keeping people keeping people away from the courthouse door. But also, even if we had a private right of action, and even if we had particularized harm, the federal courts are structured to benefit large corporations. The biggest winners in federal court litigation are always the Chamber of Commerce and its subsidiaries and its business and its members. So private right of action tomorrow is nice, but it's not going to solve anything. As a result, we need to change so many of these pieces, which is what the law and political economy movement is trying to do. Change how we think about the economy, change how we think about privacy, change the structure of governance, and also be much more active and open about the law's role in regulating economic business models.
Yeah, I think that's incredible and great for privacy lawyers to hear and be thinking about while we're sort of on the ground, right? Is that like we need to be reconsidering all of it at the same time, unfortunately, right now.
Yeah, and
But
unfortunately, privacy lawyers are complicit in not considering everything from the ground up. What too many lawyers are doing is just saying, well, I'm just representing my client, and this is what we do. We write privacy policies. Um, we, uh, um, we audit our systems by hiring an auditor that we can control, right? So lawyers are complicit in the proliferation of these data extractive models, and so are privacy professionals. What we need to do is train people better, far better, to approach their work from a critical eye. Even, I have to admit, the International Association of Privacy Professionals is complicit because of the discourses that they perpetuate, including discourses of control, privacy is control, including the idea that privacy is compliance, right? These organizations are complicit in this idea that this is what privacy is. And if we keep to this idea that only this narrow band of rights and compliance is what privacy is, then it's all lost. We might as well just all go home.
yeah, and I think the other question that people need to be asking in this discourse is privacy for whom, right? I think it's very easy to consider your interactions with Facebook as sort of like a middle class or upper middle class privacy lawyer. And even like the limited amount of time that you might have to control your data to make some of these decisions is not available if you are living precariously. And the way that your data is being used and extracted is also quite different. At the end of the day, like if I'm being sold targeted ads for Harry's razors, that type of harm is, no matter how micro-targeted it is, it's not hugely impactful to me. I might pay a little extra for a razor, but that's a quite different story when someone who's like living at the margins is being preyed upon. So that's something that privacy professionals need to consider as well.
That's absolutely right. The inequities that are born by this system. Right now, I'm working on a project about the inequities in the content moderation system with respect to queer content creators, queer content, anything sexually non-normative. A similar story, right? There are, some people might like being targeted for certain ads because, maybe they know you have a mustache, Jake, and they know you need certain types of facial hair care. And that's great because you wouldn't want to be served an ad that is irrelevant to you. But on the other hand, when the systems that are designed, which are designed in a biased way, they're designed to extract the most money out of the people that can provide it. The people who are left behind are the people who have always been left behind: the poor, those living with disabilities, those who identify as Black or African American or people of color, queer people, and so forth. And as Daniel Citron and others have showed, the internet is divided by gender. And the structures that are built by these companies are reifying all of those classifications.
Yeah, that's crucial. So I think I'd like to pivot as we come to the close here and talk a little bit about Legally Queer. Maybe you can tell us what inspired you to start it and kind of how you go about that work.
Sure. Well, thank you for asking. So when I was doing my PhD, I worked with a friend of mine whose name is Andy Toll. He used to run a website called Toll Road, TOWLEROAD, which was one of the first aggregator blogs back from, I think it was in the early 2000s. He was really one of the first, dedicated to politics and culture for the LGBTQ community. And in 2010, after they've been around for a while, when marriage litigation started to really heat up, in August of 2010 was the San Francisco District Court decision in the California marriage case. And I had been deeply affected by information from the 2008 election that showed very low participation in California, in queer districts in California in the 2008 election, even though Prop 8 was on the ballot, right? So I thought that people in our community needed to know more about the ways in which law the ways in which courts and politics affected their basic rights. So I started doing that and it was very well received, but as my career took off, that was just taking too much time. And now that I'm pivoting, my next research agenda is far more about the intersection between technology and the LGBTQ community. I started having many more conversations with queer students who felt that either their law schools were not providing a law and sexuality class, their law and sexuality classes were not talking about technology, or they found their environments hostile, or they just didn't have the kind of information. They didn't have the kind of background, the history that, Lawrence v. Texas, I was in law school at the time, that is now pretty much ancient history to some people, even though it was just in 2003. So what Legally Queer does, it's an Instagram account, starting that way, where 3 or so days a week, I post something either about what's going on in LGBT law now, or on this day in queer legal history, post about some case or some issue that was decided or some law that was passed on that day or in the past. And the goal is to highlight a couple of things. Highlight the importance of the judiciary and how hostile the judiciary is to queer rights now. To be provocative, to challenge the conventional wisdom about the courts and about the role of the Constitution in protecting queer rights, and also to engage, to get people to, if they can't donate, to volunteer for political campaigns, because politics at the local level determines law on the national level. And those kind of things aren't really taught in law school. Plus, as a personal note, it's not only really fun, and I get to work with a lot of queer students to help me do it, but also it's what we're trying to do is assemble the largest single database of queer cases in all of US legal history. So hopefully that'll be a great source for academics and researchers and advocates in the future.
Yeah, so about that database, how far back are you looking? And what are the kind of methodological choices that you make to pull those cases out? As I think going back in history, it's going to be harder to sort of sort for them easily.
Yeah, you're right. So we start in 1958 was the case of One Inc., which is the first Supreme Court case that ever dealt with anything related to the LGBTQ community. It was a per curiam decision that sent back a decision to the Ninth Circuit, which had which had said that it was illegal to send certain homophile or slightly homoerotic content through the mail under the Comstock laws, which I think many of us may have learned in law school. Comstock laws were named for Anthony Comstock, which prohibited or criminalized sending anything lewd through the mail. And those rules were applied to queer content, which prevented anything, like even a newsletter by the Mattachine Society, which just had a poem about lesbian love, was therefore considered obscene and lewd and not sent through the mail. That may seem bad on its own, but not being able to send something through the mail in the 1950s means that you can't create a national movement. So One Inc. was essentially, we're sending this back to you to change your decision based on our decision in Roth, based on new Supreme Court decisions involving First Amendment that had struck down those kind of vague laws. So what we did was went back as early as that, and then from there I developed several keyword searches, Boolean searches in Westlaw, and used some other sources. So also notably Art Leonard, who's a professor at New York Law School, has the distinction of being the founder of the first LGBT Lawyers Association. He founded Legal, the LGBT Law Association of New York, as one of the first out lawyers decades ago. And for quite some time now, he has been writing these summaries every month. Now it's called LGBT News, where he profiles some of the cases that come out in that previous month. So we've gathered some sources like that. I've created these Boolean searches in Westlaw that mention gay, LGBT, queer, or something, even old-timey words that we don't use anymore, like transsexual, which we have better terms for now, because the law still uses those. And I've created a database. So every day we can go from one day to the next, one day to the next, and find cases that are relevant. And sometimes it's a matter of piecing through lots of noise because they're not all precedential, or they're not all super relevant, or they're about, they just mention the word gay or something like that. But so it's a lot of work, and it's great that I have some Northeastern law students interested at helping some time. And I'm always on the lookout for other law students who are interested in paid positions, or to get their 50 hours of nonprofit legal work done to graduate, to help build out our database.
All right, that's incredible. It's great work. Any last plugs you'd like to make, or quick hit issues that you think folks in the privacy space should really be thinking about in 2021?
Oh my God. I mean, there are
There's
just like so many. I guess I'll just, I will end by saying that there are so many people who are in the field who are doing such great work that build on a lot of the work that we've talked about here, a lot of work on others. One of the things that I think people in the field should do is read some academics, because there's this impression among so many practitioners that all we do is we just sit in our offices with our tweed jackets and just write about stuff, and that doesn't have any actual application to real life. And of course, that's not the case. So I'll just list a few people, many of whom I'm sure you all know already, but I'll list a few people that I think people should read. Of course, Danielle Citron, the MacArthur Genius Award winner, also an advisory board and I think former board member of EPIC. Karen Levy of Cornell, who's doing work on surveillance of people at work, writing a book about surveillance of truckers. Rashida Richardson, who was formerly at AI Now, who's now joining the faculty at Northeastern working on AI and race issues. Salome Villion, who is now a fellow at Columbia, who's going on the market next year. She is just a brilliant scholar of law and political economy in the privacy and data space. She has a Yale Law Review article coming out. Julie Cohen, I think, is the canonical theoretical scholar of informational capitalism. So I encourage you to read her book, Between Truth and Power, which I think we should all become familiar with. And there are just really so many more. It's hard to leave out. It's hard to not include everyone. And I'll also add scholars like Margot Kaminsky, who's a brilliant scholar and a wonderful friend, whom I disagree with quite a bit about the GDPR and privacy statutes, but someone whose work that I think we all need to wrestle with because it's so profound.
Wonderful, thank you. And I'm just so delighted to hear people talking about political economy again. Great field. So thank you for joining another EPIC Talk.
Thanks for having me. I really appreciate the opportunity.